Alright, welcome to this week's session on Construction Management 1, Take 2. This is the second time that we record the start. What we're going to do tonight is we're just going to look at the fundamentals of contracting. It's basically topic 3 in your study guide. So the resources that you might need for this topic, you can read all the resource material topic 3.1. You can also look at the textbook by Davidson. It's the thick one, that 3-part one. If you go to section 3 of the first one, pages 1 through 69 will give you all the information. And then just as a hint also, in the first session that we had on the 14th of November, we covered a lot of that material as well. So tonight we're just going to look at the fundamentals of contracting, and that will take care of topic 3 for us. Alright, so there we go. There's two types of contract. Either it's valid or non-valid. And remember, you guys, if you have anything to say or if you have anything to add, just add in any time. Just start talking. I'm not going to, you don't have to put up your hand or anything. Just start talking and we'll take it from there. So if a contract doesn't follow the correct procedures, obviously it becomes void or voidable. Alright, so if, for instance, if we look at the slide here on the left, if consensus was obtained by improper means, for instance, you really want to do some work for the client, he's not so keen on you doing the work for him, you take out your Colt 45 automatic pistol and you get him to sign the purchase order for your contract. That would be improper means. Right? In that case, the innocent party has the choice to say, no, I want to go back, I want to be, or basically rescission means unmaking of the contract in terms of the Australian law. Right, and there's quite a number of reasons. Misrepresentation, for instance, when somebody says something that's not true, or you say that you're somebody that you're not. So for instance, if you go into a bidding session and you are going to sign a contract, you don't have the necessary board approvals. All right, so that would be a form of misinterpretation. Duress, all right, that's the one with the gun. And then of course undue influence. If you say, let's say you use the words, with the view of our continuing business relationship, don't you want to reconsider the approval of this contract? All right, so if you use some kind of means to sort of blackmail somebody, obviously that's going to come back later and bite you. Morgan, have you got input there?
Yeah, I just want to, just in regard to misrepresentation, like, do you mean that, for example, if I sign a contract for where I'm working and I don't have the authority to actually sign that contract within my organisation?
Well, it depends on your organization as well, and it depends on the client that you're going to sign. In the strictest sense of the law, yes, that would be misrepresentation, because you're supposed to go into that negotiation, that signing process with the right authority. Right, so many times you'll see that your company that you work for will honor the signature that you've made. It might cost them, because there might be cost implications for them. You might have gone in too low with the price, or whatever is the reason. So in many cases, most of the cases that I've seen so far, is the company will still honor the agreement even though it was misrepresented.
So you couldn't use it as a way out?
No, because it depends on the group that has been misled, basically. The one that suffers the consequence gets the choice of, are we going ahead or are we not going ahead? So in this case, let's say for instance you've illegally signed a contract, or you've entered into a contract to build a house for $500, and the cost should actually be $1,000. The party that you signed the contract with might say, yes, we still want to have you liable for that, and they will continue with that contract, meaning that you will still have to be you'll be forced to do the performance of that undertaking.
Yeah, that makes sense.
All right,
thanks.
All right, so we'll talk about this some more a little bit later on, and you'll also, if you go through that textbook, there's quite a lot of interesting information in there. So for instance, the contra preferentum rule means that the person that created the contract stands to lose the most. The person that gets the most benefit out of it should be the one that did not write the contract. So have a read through that. That's really interesting stuff as well. So for a valid contract, on the other hand, over there, obviously it all starts with an offer, all right, and an acceptance. All right, so we'll talk about offer and acceptance a little bit later on. So just quickly, if you guys think about offers and acceptance, let's say there's an offer on the table to buy Morgan's car, or Morgan offers his car out to everybody for $100. If I go to Morgan and I say I'll buy your car for $95, what happened to the original offer? Any question? Any ideas?
You've renegotiated it, or you're trying to.
Well, yep, that's right. But the fact is, the moment there's a counter offer, the original offer lapses. All right. So and then from there further onwards, the parties can then negotiate. But the original offer is then no longer on the table. So let's say, for instance, you offered $100 for, or you said your car is for sale for $100. I offered 95, and you said no. I come back later and say, all right, I'll buy the car off you for $100. Do you have to honor that acceptance? And the quick answer there is no, because of the counter offer that was made, the original offer is no longer on the table. All right, so keep that in mind, especially when you do negotiations on strategic contracts. All right, you might find that in many cases you want to push the negotiation a little bit further and further and further. Just make sure that you have that fallback position, that if it falls over, you can go back to a point and say, all right, up until that point we agreed, and that's the one that we're going to agree on and form the contract. All right, so the essential requirements for our contract is, of course, the must be consensus between the two parties. Legal capacity, there's that one that Morgan highlighted earlier on. You have to have the authority to sign it. You have to satisfy all the formalities. For instance, if you have to pay some kind of tax or transfer duty or anything like that on there, or the contract requires you to do specific items, that's also something that must be fulfilled. If we think about the possibility of execution, it must be it must be a possibility to actually effect the contract. For instance, if you're going to build a house designed by an architect that uses sky hooks, is it possible to do that? No, therefore the possibility of execution falls away. And then of course it has to be lawful. For instance, even if you sign a contract to sell drugs, for instance, because it's an illegal activity, it will not be a valid contract. Alright, so there's different ways of getting out of it. Either the contract runs the full term, it ends, there's various options of cancellation, cancellation due to performance inadequacies, and of course if it ends bad, it can always go to arbitration, performance damages, liquidated damages, all of those. Alright, so those are the interesting things that we have to remember. If we think about what is a contract, a definition, a quick one there, agreement which is intended to be enforceable at law. Alright, so somebody's got something to sell, somebody wants to buy it, we offer, we agree, and the goods exchange hands, and there's our contract. Alright, so can a contract be verbal? Yes, of course a contract can be verbal. My experience, of course, with verbal contracts, if it's not on paper, it's vapor, which makes it really difficult to enforce. You know, how do you record the terms and conditions of a verbal contract? It's always difficult to remember those, and it comes back later on to haunt you. Alright, so there I've given you the requirements for a contract. Basically, it creates a legal obligation between the parties, and that's really important because it now becomes a liquid document that's going to be enforceable by the courts of the country. Let's say things go horribly wrong, you can take that liquid document to the courts and they'll enforce it, make it an order of enforcement. Alright, so that's like I said, one party has something to sell, the other party has something to buy, and there's our creditor and debtor, and of course they can be both in various situations within the same contract. Alright, so keep that in mind when you talk about these contracts. Alright, so the examples, and also refer back to week 1, that presentation there. I've given you a few more in that slideshow there. Purchase orders and sale, so anything like land, cars, fixed objects, anything that you can think of. Employment, we might have a fixed term contract for employment. We might have an ongoing appointment for employment, lease, anything like that, loans, partnerships and joint ventures. And interestingly enough, these ones are the ones that's really affecting the construction industry, more so the infrastructure market at the moment. So because it's so expensive to construct these big plants and facilities, we'll see more and more of these partnerships and joint ventures. We might even see more and more of the public-private partnerships coming to the fore. Alright, so any questions so far? Alright, so nothing there. If we think about the contract, it's like playing chess. The person who knows the rules the best, he gets to win at the end of the day. And of course there are rules, and the terms and conditions that we have, those are the rules that we are going to play with. Contracts are also some kind of protection. If you think about a situation where you go to a bar late at night, early on during the evening, the opportunities are plenty, and as the night progresses, obviously less and less opportunities present themselves. Let's say, for instance, towards the end of the night you decide to go home with somebody that you met at the bar. How are you going to protect yourself? Obviously you use the necessary protection, different products that you have available, and this is exactly how it works in the construction industry. You're going to get into bed with either a supplier or a client, so you have to protect yourself, and the contract forms the protection mechanism that we have. Alright, so it provides us with the tools how to manage our relationship at the end of the day. So there's different sources of obligations that we can have. We can sign contracts. Through negligence, we can also become liable for what we've done or what we haven't done. Executive negligence. There might be laws in the country that's forcing us to do certain things. So the statutes, the criminal law, all of those play a role over there. And then of course there's a few others, that's undue enrichment, family relationship, maintenance, those types of things. All of these have an effect when it comes to contracts. So why do we have contracts? Basically it's to create a relationship between two or more parties, and it's a shifting of responsibilities, it's a shifting of accountabilities. We want to deliver something, we might want to do something, for instance, exploration of the Northern Territory, or exploration of the coast at the Gladstone area for gaseous pockets or anything like that. And it might also be a case where we use a contract to force somebody to refrain from doing something. And the best example there might be a restraint of trade contract that we have with our employees. If they work for us in a certain area, we want to make sure that when they leave us, that they are not going to open up a business in direct competition with us. Alright, so that might be an idea of a contract that prohibits somebody from doing something. So when do we see contracts forming? And it's basically when there's an offer from the one side and there's an acceptance from the other side, and it is known to both parties. Alright, so it needs to be known, and the time and place where the acceptance takes place, of course, determines the formation of the contract. So really important. You'll see when you start traveling abroad, let's say for instance Carl or Morgan, any of you guys decide to travel to the United States, and while you are traveling to the United States you are trying to sell your property in Australia. If you receive a acceptance for your offer to sell your property in the States, be careful of where you sign it, because where you sign it, actually the law of that country forms the contract. Right? So you have to follow the law of the country where you sign the contract. Right? There's ways around that, so be careful when you start traveling around and doing things cross-border. Always make sure that the domicile for that specific contract is clearly defined if you're not in the country where you are. Alright, so there we go, the offer. If we look at the different parts of the contract, we must know exactly what the giver has in mind. Alright, so this is the scope of the contract, this is what I can do for you, and there need to be no unclear areas. Everybody needs to understand exactly where it happens. Now, this is really difficult. Let's say, for instance, it's a design and build contract or an EPCM contract. Many times the contract execution will start before the designs have been completed. Alright, so this makes it a little bit more difficult for us to define. So that's where the professional services contracts and the hourly rates come in. Alright, because the more time we spend, the more we're going to pay, and the more uncertainty, obviously, the higher the price. The earlier on we want to sign the contract, the more risky it is, because the less information is available. Alright, and of course, the offer, it must come to the attention of the offeree. Alright, so as I say, both parties need to know about it. If we think about the tenders, what is a tender, what is a bid? And it is basically where we're going to say we have a set of people that we want to invite, a set of contractors, or alternatively it might be an open bid where anybody can take part in that bid. If it is an invited tender, it becomes a little bit more messy, because now we have only a smaller number of people or contractors that's going to take part in our bidding, and therefore we need to be clear as to how the allocation or agreement process is going to work. If we leave ourselves open there, we might find that we have to go for the lowest bidder or the highest bidder, if it depends on if we're selling or if we're building. Alright, so always make sure that you follow that last little point there. Invitation to tender is not itself an offer, since it's not open for acceptance by any bidder. Alright, so remember that one there. Alright, the expiry of the offer. We spoke about this briefly right at the beginning. When do we see these offers expiring? And typically, if there's a date on it. Alright, you'll see this many times if you start collecting information working on a big project. Your contractors or suppliers might say, this quotation is only valid for 30 days or 60 days or 120 days. Working with the government, of course, there's a few extensions to that rule. Alright, so always make sure that you understand that certain period of time for that specific contract. Alright, and if no period was mentioned, this one is always difficult upon expiry of a reasonable time. So let's ask a question there to Carl, Matthew or Morgan. What is a reasonable time when it comes to an offer on a construction contract? How do we determine what is a reasonable time? Any ideas?
It's determined by precedent set by previous case law.
Alright, there we go. Perfect. Alright, so and in the absence of that, it's always going to be difficult, but that's an excellent answer there. Alright, and then of course some alternatives there. If somebody dies, or if it's rejected, or a counter offer is made, or if the offer is revoked before it can be accepted. Alright, so if we look at the rejection, clarification, and revocation of an offer, remember what we said about the counter offer. The original offer then falls away from the table, and therefore we need to start the negotiation process or need to walk away from the table. The second point there, qualified acceptance. Right, so with qualified, what do we mean? It means we'll accept this offer that was made based on the following conditions. All right, so a conditional acceptance amounts to a counter offer, therefore effectively removing the offer from the table. All right, so that's important as well for us to remember. It might come back later. All right, so any questions so far? You guys just start talking. The acceptance.
Yeah, Josh.
Yeah, Morgan.
What was that answer that I'm not sure who gave the answer before, but what was the answer for when I?
All right, so Carl gave us the answer. Carl, I might just ask you to repeat your answer because it was really good, and then.
It's under law of contract. It's determined by precedents, and that comes from previous cases. Cases escalate through different court systems, and the higher you go, the more more valid the outcome is. So if it's a high court case, that will determine what other lesser courts will look at in determining what is a reasonable time. Questions of law are always determined like that.
Yeah, makes sense.
Yeah, that's really a good one there. Thanks, Cole. All right, so onto this slide, the acceptance. All right, in order for it to be a valid acceptance, non-negotiated, it needs to be the whole package. All right, unconditional, no conditions, or unqualified, and of course the person that it was addressed to must obviously be the person that's going to accept it. All right, and if we look at the formation of the contract, when do these contracts come into life? Is it where the offer was made, or was it at the time that the agreement was reached between the two parties? All right, and the key here is the contract is concluded at that moment where the acceptance of the offer is communicated. All right, so let's say, for instance, one of you are far away, and the acceptance of that contract or the acceptance of the offer is made by email or post. How will that influence the formation of the contract? Does it come into effect the moment you receive the envelope of acceptance, or does it come into effect the moment the envelope has been posted?
Joshua, the postal rule applies. Emails aren't viewed as being legally binding in this country as yet. There's no case law to substantiate that.
Excellent, great stuff. Thanks, Carl. That's a real good answer as well. Emails, electronic means not yet recognized. So there we go.
Faxes are recognised under case law, but not emails as yet.
All right. All right. And Morgan, have you got a question there?
Oh no, just an answer for the mail. Isn't it on the day that it was posted with the stamp, the postal stamp?
That's correct. That's the postal rule.
Yeah.
All right. All right. Great. It's actually really nice that you guys take part, because it makes it a lot more interesting. And guess what? There's our next slide dealing with exactly what Carl has just told us. And if it was mailed by post the day that the envelope obviously is posted, that's when the contract comes into effect. All right, so there we go. If we look at the place of formation, really important, that example that I used previously, the relevance is, of course, what law is applicable, right, and which court has the jurisdiction, and of course if there's a restraint of trade that's been contravened. For instance, if we are not allowed to operate in a certain area because of a previous contract that we have, or a previous agreement that we have in place, obviously that will have an influence on our execution of that contract. All right, and a quick question, and this one specifically goes out to Carl. A letter of intent and the letter of award. What is the Australian perception of letter of intent and letter of award?
Okay, I haven't come across a letter of award yet, but letter of intent shows an intention to enter into a contract. It's not a contract as such. It's just an intention. That's it.
All right. So legally, it has no feet to stand on, right?
It depends, actually. There is some lower case law out there which does give it some credence.
That's right. All right. So this is a really interesting thing. The letter of intent is almost like being pregnant. You know, it's really difficult to see if it's going to have an effect or not. And Carl is 100% correct there. There is some lower case law that indicates that it is. If you have an intention to enter into a contract, it might allow the contractor to actually move on site and do some of the early work. All right. My experience of a letter of intent is, of course, that it does not have the functionality and the effectiveness of a full-fledged contract. So if I was a contractor, I would avoid it at all costs.
One thing it does show, though, is an intention of the parties to be legally bound at some stage. It's sort of like an engagement. You know, the courts will look at it and go, well, there was an intention there, but you didn't sort of follow through with it. You know, you broke up beforehand, before the marriage.
That's right. Yep. I agree. I agree there once again. What about the
Yeah, Josh.
notice of award or letter of award?
I actually haven't come across one of them. I did contract law at uni, but that never came up, so that's not one I'm
Wouldn't that
familiar with.
All
wouldn't
right.
that just be the letter on the front of the contract saying, "Here's the contract"?
Yeah, Morgan, you're almost right there. A letter of award or a notice of award is actually, it's that actually forms a legally binding contract. So it's more powerful than the letter of intent because it's basically a notice of award saying we've looked at your offer and we've accepted it, and therefore we've awarded this contract to you, and only the following things are outstanding. And typically, the notice of award, basically the only thing that's outstanding is signatures of the signatories, and it might be because there might be a delay getting all the same people in the same room or getting the contract signed or something like that. But that would actually allow contractors to get started on site and execute the jobs. All right, so really interesting stuff here. Yeah,
Josh,
yeah, Morgan.
Josh, just with the contracts that we let, for the other guys that don't know, I work in commercial construction, and we basically let a lot of letters of intent, and a lot of the guys have started work already without us actually issuing a contract. But in the letter of intent, we actually specify, like as per negotiations, and we actually include the scope of works that was agreed to and signed on, and the contract sum, and payment terms, and liquidated damages, and retentions. So we do actually list quite a lot of it in the letter of intent.
Mm-hmm. What do you guys, Morgan? What do you guys do with the insurance aspects of a letter of intent without having that formal contract in place? Because obviously, the moment you have the formal contract in place, the risks are better mitigated because of the contractor's insurance. How do you handle that in a letter of intent?
Usually we don't let the guys start on site until they give us a copy of their insurances and all their up-to-date Incolink and WorkSafe documents and all those sort of things. So
The other way of doing it is also you hold a bank guarantee as retention against them right from day dot too.
Yeah, that's
yeah. Too.
I would also go that route. Matthew, have you got? I see that you've unmuted yourself. Have you got something to add? All right, so obviously not. Let's all right, so let's get going. Continued. So remember we spoke about valid contracts and then the 5 contracts. Carl, you'll most probably remember this from your days at uni. Consensus, we spoke about that one. Physical possibility, lawfulness, you're not supposed to do anything illegally. The formalities, and then of course the contractual capacity. And if any of those are not there, it will lead to the invalidation of that contract. Alright, so just a few definitions on the main ones there. What does consensus mean? It means that everybody that's going to be part of this contract unanimously agreed to it. There was no undue influence, and basically everybody is happy with what they have on the table. So there's a meeting of the minds. Everybody agrees with what's on offer and what's to be accepted, what needs to be done, and who's going to do it. All of that forms part of consensus. The elements that we have to agree upon is who's going to do what. When is the time going to be? Is it going to be a long-term contract, short-term contract? And remember, it's different to having a social agreement, right? Social agreements not really enforceable, so it makes it more difficult. There's our little example that we spoke of earlier on. You guys can have a look at that later on. This one also interesting. Carl, you might have some notes on this. Interesting one where an answering machine comes into play, all right, and the two parties are not yet familiar or unknown of the offer and the acceptance at that point in time. All right, so if we look at the error or mistake, how do we handle that? If both parties are under the incorrect impression, how will it affect the execution of that specific contract? Can we move it back? Can we undo the contract? Who is it going to benefit? and to whose detriment is it going to be. Right, and then of course it depends on the situation that we find ourselves in, and the identification of the subject, the concluding of the contract. Is it such a type of contract that even with the mistakes that we've made, we can still force it through to conclusion, or do we need to say stop, let's cancel it, move back to the point where we have our fallback position? And then of course the nature of the transaction over there. Right, so the rescission, that's basically the unmaking of the contracts between the two parties. We're unhappy with what we've done. Might be because of misrepresentation, remember the first slide, and duress. Any of those reasons might be valid for pushing back the contract and saying, I'm going to move back to the point where I was before I entered into this contract. Alright, and then of course there's our innocent party. They have the choice of what to do. They might also decide to move forward, keep the contract going at that point. Physical possibility. Remember our example of skyhooks. Is it a possibility to use skyhooks? No, it doesn't really work, and therefore it becomes impossible. For impossibility to be absolute, skyhooks would be an example of that, because it's impossible for everyone to use skyhooks. If it's relative, it means that it's only for the party to the contract, only the debtor in the contract, it becomes impossible for him or her. Alright, so for instance, he becomes bankrupt or insolvent, therefore he cannot execute his contract any further. It becomes impossible for him. Alright, we'll talk about bankruptcy and solvency a little bit later on during the course as well. And then of course the impossibility for the debtor does not matter if it's possible for others. Alright, so once again, relative and absolute, the two terms that can be remembered there. And there's just a small little example of impossibility that you guys can look at your own time. If we have a quick look at it, in this case A sold the premises to B, and because A was not supposed to be, or was not in a real position to sell the property to B, performance was subjectively impossible. Alright, and therefore it wasn't a valid, it was a valid contract, but A became liable for that contract as such. Alright, so there's many instances of this in the Australian law, so you can go and have a look at those. Lawfulness, alright, remember what we said, selling drugs, selling anything illegal, moving over a protected area, or moving ahead with a contract without the necessary approvals. All of those have impacts on the legality of our contracts. Right, and prostitution as well can also be, in some countries it's legal. I don't think, as far as I know, in Australia, no, not yet. Alright, so if you enter into a legal contract for the services of a prostitute and you fail to pay, and later on her mate, Booba, comes and knocks you out, you might find it difficult to defend yourself in law in those circumstances. Alright, and then the contractual capacity. You must be competent, you must have the correct authority, either by board resolution, whatever the conditions are for your specific employment or for your ability to or capacity to contract. So this one, Morgan, this is the one that we spoke about earlier on. If you are going to sign the contract on behalf of your company, you need a board resolution typically that allows you to sign the contract, and that board resolution will be specifically drafted for that specific contract. Alright, so formalities that we have to satisfy. For instance, the sale of property must be in writing. A verbal contract can sell anything else, but for property immovable goods it needs to be in writing. Alright, and there I've just given you another example to have a look at. Right, the terms and stipulations, basically this is dealing with the rules of the game that we're going to follow. It sets up the game plan between the two players or the parties to the works, and then of course we also have expressed and tacit or implied terms. Alright, so tacit is always the soft ones, difficult to prove, and it's based on the circumstantial evidence that's available at that time. Innocent bystander tests, this is the get a fix character out of the Asterix and Obelix books. The old guy standing next to the road, or next to the road, how is he going to call a decision? Alright, so the innocent bystander test doesn't understand or have prior knowledge of that contract. How would he react in that tacit case? Alright, the contents of a contract. Alright, the essential stipulations, the natural stipulations or implied. So essential, we'll talk about that just now. Those are the specific ones that needs to be part of a contract. And then of course terms, conditions, and anything that you need to add. For instance, in your case, scope of work documents, specifications, EIAs, environmental management plans, all of those would form part of the contract. The essential stipulations, basically the terms for the classification of the contract. Right, so is it going to be a professional services contract? Is it going to be an executing contract? Is it going to be a scoping contract? All of those we have to decide on. Also the type of strategy that's going to be used. Is it going to be an EPC, EPCM? How are we going to function after we've signed the contract? Right, so there's also going to be the legal rules, comes with the essential stipulations. Alright, and then the natural stipulations, because of the type of contract that we've used, and these do not necessarily have to be included. They are always going to be implied. Alright, so for instance, the protection against latent defects, all of those becomes part of the package that you basically sign, and it's there to protect both parties. Alright, so it's the mitigation of risk for both of them. Alright, and it's based on reasonable and fair principles. Once again, case law will preside there, and it might be, in some cases, be excluded by parties to the contract. Alright, so some additional terms that we might have, special requirements that you have in the execution of the contract. It needs to be come up with by the parties to the contract, and all of the participants or role players have to abide by those specialist terms that we have for that contract. A few examples of incidental terms: time restraints, meaning that after a specific date we're going to have liquidated damages, or alternatively, in this case, when something happens, right, suspensive clause, if somebody dies, if it rains tomorrow, anything like that. The same with warranties. Alright, and that's depending on the type of contract that we have. Breach of warranty is of course a breach of contract, and therefore it becomes problematic for us. Alright, so have a look at those. Lots of information in your textbook on warranties as well. Have a look. Alright, so that's basically what I wanted to do tonight. Any questions from you guys? Any suggestions? Anything about the assessment item that you want to ask before we call it a night?
Actually, I've got a question in regards to the first question in the assignment.
All right.
The type of project conditions that you expect. Do you mean physical conditions, contractual conditions?
Actually, yes, Carl, good question. For that one, I was expecting a little bit of the contractual conditions. All right, so not the physical conditions, yep. The contractual ones. And you don't need to write volumes, you know, try and keep it as succinct as possible, just a few ones to say, in my experience, this is what I expect to see, and this is how I'm going to handle it.
Good. I've just put it down in point form. That's all I can fit with the word limit.
Yeah, that's fine. You guys will see when you get to know me. I like bullets. It makes it easier to mark, because if there's 40 people in a class, you know, it becomes a lot of reading to do. So I understand, you know, I've also got the textbook. You don't have to rewrite the textbook, so perfectly good. Bullet points works for me.
So shorter word counts also makes it easier for you?
Well, there's always limits, Morgan, and I can see where this is going. You see, always the chancer, eh? Well, the word length there, it's indicative. You know, if you want to go 15% below or 15% over, I'm still going to read it, and if the information is there, if you've covered the answer, I'm happy with it. I'm not going to count the words. It just doesn't make sense to do that.
I'm just joking.
Yeah, no, it's alright. I made a note here in your file.
Yeah.
Alright. Any other questions?
I'm starting to believe you about all these marks now that you're making up next to my name, because when my assignments come back, I think it's showing.
Yeah, no, that's, I do, all the other students, they barely have a file. I mean, the information on you is already on a compact disc, so it's quite a lot.
Joshua, with question 1, there's a couple of scenarios where I can use the EPC contract, but I don't want to kind of double up on it. If I use an alternative contract, I just have to back it up with the reasons as to why I've chosen
yes
that over the EPC?
That's correct. Yes, that's exactly correct. So in many cases, the case or the little examples that I wrote there might be some overlaps, and it's fine to use the same one, but you can use alternatives. And you can say, in this case, I'm going to modify it slightly to fit this condition better. Or I'm going to add this section of commissioning, for instance. So for instance, I would give you small little hints there. For instance, if you look at number 3, it says a single point of responsibility for a greenfields multi-project complex, including interface management, where the contractor is responsible to pay all subcontractors. And there's your hint, where the contractor is responsible, because it becomes a management type contract. So you have to think, all right, what?
Yes, I was looking like a design management managing contractor.
Yep, that's fine. And for those, I mean, it's nice if you want to draw for each of those little scenarios, draw a little sketch and say, this is, those little diagrams, the client sits on top, this is where my management company sits, and this is where my contractor sits, and this is where all the subcontractors and the suppliers, and draw lines, like an organizational structure, org diagram, for instance. That makes it nice and simple, and that might help you to get past the word count as well.
Right. Thanks, Josh.
What is interface management?
Well, interface management is where you have different services in for instance, a big plant, or a oil and gas, or a gas to liquid facility. You might have electricity. A simple example would be an interface between the electrician and the plumber. How are you going to manage that? Alright, so on this case, for instance, you might have a tank farm to the one side, you might have a nitrogen plant on the other side. How are you going to manage the connections between the different parts of that project? For instance, this one says a multi-project complex, so you're going to have a tank farm, definitely there might be a nitrogen plant, or different types of plant. There might be a gas to liquid facility as well. And just think about it in your mind. How will you negotiate? How will you work out the lines there? It's all theoretical, Morgan. So don't overcomplicate it.
No, I'll definitely try not to.
All right.
This one, in the scenarios you say, or in actual questions, says typical documents. Like, what would you say? Like scopes, obviously scopes of work, but bills of quantities, or
Yes, that's a good example. So if you are going to use, for instance, a remeasurable type contract, yes, bills of quantities is always a good start, but a scope of work, specifications, EIA, environmental management plans, Carl, that stuff that you sent me recently, that would typically be all of the types of documents that you would want to list in there. And of course, list them, give a short description, bullet points. That's what I want there.
That would sort of run across quite a few of them, though, wouldn't it?
Yes.
Quite a few of the documents.
That's fine, and it's fine if you create a table or something to say this is information that's relevant to all of the above scenarios. This is what I expect for 1. This is what I expect for 2. You can break it up in that sense, So what I suggest is you create a table and say these are all the different types of documents on the left-hand side, and it's present in 1, 2, 3, and 4, and put tick marks, and make a little table to explain your point. That might be a good idea.
Josh, just with question 2, I was having a read of that today, and says to produce a professional report for your CEOs. Is that report to include both projects in one report?
Yes. What you're going to do there is you're going to analyze both of these projects, and you are going to identify the 10 most important selection criteria for each of the projects. Now remember, these 10 that you've identified will not be the same for both projects. What you're trying to find is, are there some of these selection criteria that are always going to be there? For instance, a good example would be a scope document, or the I think, what did I call it? I called it a project scope appreciation. If you look at that, that's always going to be a fundamental part of a contract or of a project. So try and see if you can find correlations and try and explain why it's always there or why it's different for the 2 scenarios.
Joshua, with question 2, are you also trying to identify elements of risk within those projects?
Yes, there's a few things. Yeah, no, that's right, Matthew. There's a few things that I've given you hints on. So, for instance, you know that the university is all about cultural, cross-cultural competence and risk management and all of those things. So you'll see there that I've sort of tried to bring in. You have to think about how will it be working in a different continent. How will you address it? So you have to go and at least go to Wikipedia or Google and try and find something about the cultural business rules that you have in Africa, for instance. If you go to a meeting in Africa and you're on time, you're going to most probably wait for 2 hours because it's normal for them to come 2 hours late. It's expected. So that's something that you have to think about. And that's, I think there's somewhere in there I said motivational spending. So effectively, what is motivation? It's bribes.
Bribing.
Yeah, that's it.
TIA. This is Africa.
I didn't say it. I am from Africa. I'm allowed to say that.
Yeah, me too.
All right. So any other questions there?
The aluminium smelter in question 2, is that the one where the Russians had a $300 million learning experience?
That's the one. That's the one. Yes, Carl. If you if you're familiar with that one, that's exactly one. That's why I chose it. It's working in Africa is never easy.
They shut the plant down, didn't they?
I think it's been restarted. As far as I know, I left there about 2005, and at that stage, that plant was still running. So this Ikot Abasi, that's the one that I worked on. So that one is still running, as far as I know. I haven't been back there for a few years, but I think it's still there.
Was that the one where the Nigerian locals were abducting workers off site and holding them for ransom, and
yes,
there was gas supply issues? Yeah, I know it now. Yeah,
that's the one. We actually had a barge. We at one stage lived on a barge, and then the Nigerians got boats and they started hijacking our barges as well. So it's a no-win situation.
Yeah, they even had a crack at the oil rigs, didn't they, at one stage?
Yes, they'll have a crack at everything. Well, maybe maybe one night I'll show you the photos of the Escravos GTL, that gas to liquid plant in Escravos. I'll just compile a bunch of photos and you can see what it looks like. We actually had to create an artificial island to house the 5,000-man camp that they were building there. So, but they come across the river, they come across in boats, and just take everything. So it's a different life.
So you never had a dull day at work then?
Oh no. The only dull days you have is when you're back in, Johannesburg or Pretoria, and you sort of everything runs according to plan. But in Central Africa, no, it's never a dull day.
Sounds fun.
Yep. Alrighty. Well, there we go. If you guys don't have any other questions, I don't want to keep you for too long. Shall we call it a night?
Done deal.
Alright, great stuff.
Yeah.
Alright, I'll post this video as soon as I can, most probably only tomorrow. Then you guys, the presentation is already there, and I'll see you next week.
Cheers.
Alright, if you have if you have questions before then, welcome to put it on the forum, and we might do another session towards the end of the week. Alright.
Okay.
Alright.
Thanks, Joshua.
See you guys later.
Thank
Bye.
you.